On September 29, 2019, Deputy James and Deputy Zhang from the Shelby County Sheriff's Office in Tennessee, a potentially dangerous engagement unfolded due to their reckless actions. The incident began when the officers responded to a call regarding a package theft based on doorbell camera footage. The complainant, Mr. Aaron Branch's girlfriend's mother, alleged that a neighbor had taken a package from her porch. Upon arriving at the scene, Deputy James and Deputy Zhang engage with the witnesses, specifically Ms. Vernita Eccles, who identified the neighbor across the street as a suspect. She further mentioned that the neighbor might have a bench warrant for her arrest. Within minutes, the officers made their way across the street to confront the neighbor, seemingly without validating the claims made by the callers. Surprisingly, Deputy James immediately announced his intention to arrest the neighbor without properly investigating the situation. It was during this engagement that Mr. Branch, the original recorder of the incident, arrived on the scene while openly carrying a firearm on his hip. He questioned the officers about the package's ownership, leading to Deputy James ordering him to disarm for officer safety. However, Tennessee law permits citizens to bear arms for self-defense, and there's no requirement to disarm themselves around officers unless there's a legitimate safety concern.
Yeah. Okay, now that box that came off the front porch, did y'all see a name on that box by any chance?
We didn't get a chance to look at it because it was stolen before we got a chance to.
Now, if we show you guys what the box looked like, how you doing, sir? Are you an officer, sir?
Put your hands up, man.
I don't need to put my hands up.
This is for officer safety.
I don't need to put my hands up.
Put your hands up, dude.
The situation escalated as Deputy James unholstered his firearm, which Mr. Branch rightly challenged. This action was unnecessary and potentially dangerous escalation, as Mr. Branch was not displaying any behavior that indicated he posed a threat to the officers. Deputy James cited a state statute to justify his actions, but his interpretation was flawed considering the circumstances. Furthermore, the officers threatened to arrest Mr. Branch and his girlfriend for disorderly conduct, despite being on private property.
The proper procedures, you're supposed to ask if he has his handgun permit.
You don't know. Okay.
Yes, I do.
Hey,
yes, I do. We went to the class. Yes, I do.
I don't need to keep my hands up.
Yes, put your gun away.
This is for officer safety.
You asked to see his permit.
Okay, can he just step in the house then?
No, I need that.
We're not talking to you, man.
I'm in my car right now.
We're not talking to you right now. We're not talking to you right now.
Go in the house then.
I don't need to go in the house. I haven't committed a crime.
You have a permit.
Where's your permit? Amber, record Officer James. We're gonna make a start today. I'm gonna make a start at James today. I'm gonna make you a start, James. I'm gonna make you a start today.
Step away, man. We're not talking to you.
Okay.
Let me see your permit. Keep this arm up. Let me see your permit.
I don't need to keep anything. I can do whatever the
This is officer. No, sir.
do what you do. Do your
Police officers are. Police officers are in your presence.
The First Amendment protects speech on private property, and the officer's threats infringed upon this right. Legal precedents underline the special protection for personal liberties within one's home. The officer's subsequent behavior with an unidentified woman, initially detained due to the reported theft, raises Fourth Amendment concerns. While reasonable suspicion justified her initial detention, the officers extended her handcuffed detention in a police cruiser even after she provided evidence that could have dispelled their suspicions. Courts have ruled that such extended detentions could transform investigative stops into arrest, violating the Fourth Amendment.
There it is.
You go
to law school?
I did go to law school.
Okay, you passed the bar?
I did
So
pass
you're
the
a
bar.
lawyer?
I am a lawyer.
Okay.
I don't have to disarm myself. That's not how the law works.
Come here.
I'm not going anywhere with you.
Just go
I have not committed a crime. They know I haven't committed a crime.
Okay,
They know I have not committed a crime. Amber, I want you to record them. I'm gonna make stars out of both of them. James and Zing. I'm gonna make big stars out of them. I love tyrants. I love tyrants like yourself.
Either you step inside or you go to jail.
I'm a law-abiding citizen.
5, 4,
I'm not your child.
Wait, hold on, wait.
I'm not his child. Bro, you're not scaring nobody with that fucking permit.
Question or whatever.
You're not talking about.
Despite these issues, Mr. Branch managed to de-escalate the situation through assertive dialogue. He challenged the officers' actions while maintaining composure and asserting his rights. Eventually, the officers released the detained woman, but not without her being held for an excessive duration. Now, let's move on to the next investigation. In an incident that occurred on July 3, 2021, officers from the Elkhart Police Department were called to respond to a disturbance at a hotel in Elkhart, Indiana. The officers stopped 3 teenagers whom they believed to be responsible for the disturbance and demanded that they identify themselves. As tensions began to rise, one of the bystanders at the scene started recording the encounter.
Who I am.
It doesn't matter. Talking about us.
It doesn't matter. It doesn't matter. He doesn't want you guys back here. And to verify that, I need your names so that if you do show up again, you can then go to jail. Okay?
So
what is your name? Before I put you all in handcuffs and take you all to jail. Okay. Then you're gonna.
I ain't gonna lie. I ain't going to jail, man.
What is your name?
Y'all ain't got no ride, man.
We do. We waiting.
Despite the potential escalation, the officers did not conduct a thorough investigation into the situation. According to best practices for police interactions, responding officers are expected to perform comprehensive preliminary investigations, including interviewing witnesses to accurately determine suspects. However, the officers in this case seemed uninterested in investigating further and instead continued to insist that the teenagers provide their identification.
Because we can't verify that you are the parent or guardian? We can't. So again, I'm going to ask again before you all go into that. Does that make sense? What is your name? We can't just release it.
Let me talk to them. Let's talk to them.
But if they weren't part of the confusion, then I don't understand what's going on.
I told you multiple times.
The boys and bystanders maintained that they were not involved in the initial disturbance, but the officers did not seem willing to consider this possibility. The officers' conduct raised questions about their failure to follow proper investigation procedures, even though there is no legal obligation for police officers to conduct in-depth investigations.
You're not in trouble, man. But if you keep playing this game with us,
I want him to come out here before I say anything else.
They gone. They went out the back door. They went out the back door.
No, I'm talking about the manager that said that we was because he know it's not us.
No, it wasn't them.
Exactly. That's why I want him to come out here.
He doesn't want to come out here right now. Okay,
Man,
he has a job to do, which is inside. No, because he doesn't want you inside. He doesn't want you on the property.
He don't know it.
The bystander recording the incident questioned the officer's authority to detain the teenagers based on Indiana's trespassing laws. He argued that since the teenagers had not refused to leave the property when asked, they could not be considered trespassing. The officer countered by citing Indiana trespassing law, which allows charges to be brought against individuals who knowingly or intentionally refuse to leave private property after being asked to do so by the property owner or their agent. However, legal precedent indicated that a police officer who is neither the property owner nor an agent of the owner cannot create a trespass violation merely by asking someone to leave and then arresting them for noncompliance. In this instance, the officers were acting in their capacity as police officers and not as agents of the property owner, so their detention of the teenagers on suspicion of trespassing seemed unjustified.
You know how easy this is? You can't go to jail.
These are not them.
So, would you like these gentlemen also trespass on the property?
We didn't have nothing to do with it.
Yes.
No, they had nothing to do with it.
All right, man, get my... Stand up.
The other dude jumped out the gun.
It was taller boys who are probably already all gone because they knew that you were coming and they don't want to
That's why
deal
I
with police.
until he come out here.
Fair
enough, but when I walked in, he pointed to you
Yeah,
gentlemen.
man, that's
Right
why I
now,
want him
you
to
got
come
my-
out.
you
It
didn't want to come out.
It wasn't that hard for him to come out here and clear it up. He trying to put him in here to take him to jail.
Because you're not cooperating.
You're not doing his
It's
job
easier
right.
for me to control the
Not doing his
situation.
job right.
I am doing my job right.
See, y'all don't know
What's your name, badge number?
He was talking about. They was in there talking about gunplay with this dude, man. That's
Sure,
what I said,
and
y'all
when I
didn't
got
have nothing
here,
to do with
listen,
it.
when I got here,
Yeah.
he pointed to these gentlemen.
We told you it was
Okay.
The description that he gave.
I can't take your word for it when he pointed to you.
Furthermore, Indiana law does not have a stop and identify statute that mandates individuals to provide identification during criminal investigations. The statute requires individuals to provide identification to law enforcement officers, and that only applies when someone is stopped for an infraction or ordinance violation. This means that the officer's demand for identification lacked a legal basis.
He did. He pointed to you.
already in there,
He
bro.
pointed to you. Okay.
Name and badge number, please. Is an Elkhart policy for you to identify yourself to the public?
My guess is they probably already left
Okay.
because they all probably have their licenses.
That's fine.
And they drove off because they didn't want to deal with you guys.
The situation escalated further when one officer claimed that the hotel manager had misidentified the teenagers as the perpetrators of the disturbance. Despite the assertion from the bystanders that the detained teenagers were not involved, the officers seemed unwilling to reconsider their actions. The bystanders and teens remained composed, and with the intervention of the bystanders, the officers were eventually compelled to release the teenagers. Now let's take a look at another investigation. In a notable incident on June 12, 2020, a confrontation between an Amazon delivery driver named Deja Murphy and property owner Keith Miller in Lowell, Indiana, has brought to light the complexities of enforcing laws on private property. The incident, originally reported by the Times of Northwest Indiana and discussed on Lackluster's channel, involves issues related to traffic laws, private property rights, criminal confinement, and police authority. The situation unfolded when Miller, convinced that Murphy was speeding on his property, employed his truck to block her exit.
Good luck, buddy.
No. Bottom line is, I need your ID.
Sure.
You're going to pull your truck in your driveway.
Yep.
I'm going to get her information. I'm going to do a report, and we're going to go about our day.
I'm going to get my wallet from my office.
Huh?
You're
not. You're going to just give me your name and information.
Oh, sure.
I'm going to...
You want me to write it down for you?
Yeah. I'm not spending all day with this. This is
I
ridiculous.
asked, and we have since put cameras up. I just said...
What's your last name?
Down. Miller, M-I-L-L-E-R.
He proceeded to demand her identification, thereby initiating a tense standoff. Responding to Murphy's call, Officer John from the Lake County Sheriff's Department arrived at the scene. He clarified that he lacked jurisdiction to enforce speeding laws on private property, igniting a discourse on the distinction between public roads and private driveways. Indiana's legal framework underscores the limited jurisdiction of traffic laws on private property. State law specifies that highway regulations pertain to publicly maintained roads accessible for vehicular travel. In contrast, a private driveway, such as Miller's property, doesn't fall within this category. Therefore, Murphy's alleged speeding on the driveway couldn't be penalized as a traffic violation under Indiana law. However, exceptions do exist. In certain cases, police can enforce traffic rules on private property where the public's invited. This enforcement relies on local ordinances and agreements between property owners and law enforcement authorities. These provisions empower the police to regulate traffic and parking on private property under specific circumstances.
Thank you. Sorry. Pull forward.
Okay, ma'am. I need your license.
Okay. And may I ask why
Because you called the police, he called the
Okay.
police,
Just making
and
sure.
I'm called here. That's why I need your information. That's all the information I need. And he's upset because you were speeding.
But
I
y'all
told him
was-
he couldn't do what he's doing.
And
You're going to go on your way, and if you have any issues, you and your company can stop delivering here.
Okay.
How's that?
He came to my door. That's what bothered me. He came in my door, opened the door, told me to get the hell out my door.
While these local ordinances may not encompass the full scope of state traffic laws, they still grant authorities the capacity to uphold specific regulations. Miller's actions also raise questions about potential criminal charges. Officer Marshall suggested that his conduct might align with the crime of criminal confinement, defined as knowingly or intentionally restricting another person's liberty without consent.
That's harassment.
You know what? Let's stop.
Okay.
We're going to do a report. We're going to go about our day.
It's harassment, though.
Everything's everything. You know what?
That's harassment.
There'll be a report on file.
While Murphy's situation didn't precisely match this definition, it highlighted the broader issue of maintaining public safety and individual rights on private property.
To the prosecutor's office?
This is Lake County?
Yes. We'll give you a case number.
Yeah, I want the case number, please.
It'll be on the report, sir.
What's your name?
It'll be on the report. It's Marshall.
Marshall?
And tell your friend on the phone, I'm not upset with you.
That's my brother.
You know what?
You know where everything's going on? That's the only reason why
Everyone's fine. We're here. I don't need your brother telling me my job and what we need to do. I think you need to get a hold of your supervisor and tell him
no, we already talked.
Okay.
She was on the phone when all of this
Get a hold of your
happened.
supervisor. What's the phone number you can reach that?
219-779.
The incident also touched on the concept of harassment. However, Indiana law defines harassment as involving communication with an intent to harass, annoy, or alarm another person without legitimate communication. Because this definition doesn't cover in-person interactions, Miller's actions toward Murphy, while unsettling, might not fall within the legal definition of harassment. Fundamentally, the incident underscores the scope of police authority concerning private property and the need to strike a balance between individual rights and public welfare. Indiana's police power enables the state to enact reasonable restrictions on private property to ensure community safety, health, and morality. While the jurisdiction of traffic laws on private driveways remains limited, criminal violations, regardless of the location, can still lead to police intervention.
Police officers sure are law enforcement officials who are tasked with maintaining public order, protecting individuals and property, and preventing and investigating crime. However, there have been instances where police officers have abused their power, used excessive force, and violated people's rights, particularly those from marginalized communities.
Somebody help me!
These actions can lead to distrust and fear of law enforcement, exacerbating already strained relationships between the police and the communities they serve. But can they exploit such power? What are the legal penalties if they do so? And if the police abuse his here power, would they be treated differently? Stick around as we take a closer look at two of the most brutal cases that could make us think of cops as judicial pillars twice. Our first case kicks off with Sergeant Mario Cardona versus Daniel Garza. Daniel Garza was helpless after being thrown and pinned to the ground. Officer Mario Cardona, who Garza had known for years, was on the verge of breaking his wrist. Garza recalled, "I was trying to be a man and trying to hold in the pain, but man, that wrist lock hurts." He's just bending it and bending it. But what compelled Cardona to go so far? It turns out that his actions were motivated by rage toward Garza, whom he accuses of attempting to kidnap his stepdaughter. Are cops bestowed such authority? Seems that the two men had quite the history, with Garza having previously dated Cardona's stepdaughter, Naomi Villanueva. The relationship had hit rock bottom, with Villanueva moving out of her parents' house to live with a friend. In May 2015, Garza allegedly took Villanueva without her consent from her friend's house and brought her to her parents' house in Whittier, where Cardona lived across the street. Cardona saw Garza doing pilots in his yard and ordered him to come down to the street. As soon as Garza came down, Cardona began his assault. According to Garza, he was not the aggressor, and a neighbor who witnessed the incident testified in Garza's favor. The sheriff deputies who arrived at the scene noticed redness on Garza's face, bruises and abrasions to his knees, and redness on his wrists. Garza filed a complaint against Cardona, which led to a federal lawsuit against Cardona, Chief Beck, and the city of Los Angeles. Garza alleged false arrest, unreasonable search and seizure, excessive force, assault and battery, negligence, and intentional infliction of emotional distress. A video of the incident filmed by one of Garza's neighbors was also presented at the trial. They had made up a story of what had happened to make him look like a hero and me look like a criminal, says Daniel Garza. The U.S. District Judge Stephen V. Wilson presided over the hearing where the former Deputy City Attorney, Michael Amarian, spoke in defense of the city. The jury found Cardona to be acting with malice as an off-duty officer, and on June 26, 2017, they ordered him to pay Garza $210,000 in damages. On top of that, the court added another $664,000 in attorney's fees and $26,000 for post-trial costs. The City of Law refused to take responsibility for Cardona's actions and even refused to indemnify the officer, forcing him to pay for the charges out of his pocket. Jim DeSimone, Garza's attorney, claims, "This is the problem with the left. This is why people are out on the street." The case is a clear example of police officers using excessive force against individuals and getting away with it. In this case, however, Garza was able to stand up to the authorities who violated his rights, and he was able to win his lawsuit against Cardona. The jury's decision to find Cardona guilty of acting with malice sends a strong message that law enforcement officers cannot get away with using excessive force against citizens. It is worth noting that this case also highlights the importance of civilians being aware of their rights and standing up to law enforcement officers when they feel their rights have been violated. Garza's decision to file a complaint and a lawsuit against Cardona shows that individuals can take action against police brutality and excessive force. As more and more people become aware of their rights and are willing to take action, law enforcement officers will be held accountable for their actions, and if you sue a cop in LAA for excessive force, you are in for a wild ride. However, Garza's decision to stand up to Cardona and the authorities who violated his rights resulted in a victory for him, sending a strong message that law enforcement officers cannot get away with using excessive force against citizens. The case of Harold Hill is just a perfect example of how our justice system can go wrong. From a gruesome rape and murder to a wrongful conviction, this case definitely ticks all the boxes. So, what underwent? First off, we have the detectives who were assigned to the case, Kenneth Bordeaux and John Halloran, the so-called beacons of justice. They were the ones who got the confession out of Peter Williams, who was later found to be in jail at the time of the crime. So, how did they churn out a false confession of someone who wasn't even there? Hill's confession is also questionable, as he claims that he was physically and mentally abused until he confessed to crimes he didn't commit. Is this the kind of behavior we expect from our law enforcement officers? Moving on to the trial itself. Hill was only 16 years old when the crime was committed, but was tried as an adult at the age of 31. This is an interesting move from the prosecution, considering that neither of the defendants had a criminal record prior to the incident. The jury found Hill and Young guilty of murder, and they were sentenced to life without parole. But 13 long years later, DNA tests revealed that the hair found at the crime scene and the cellular materials under Kathy Morgan's fingernails didn't match either of the defendants. Think of the agony Hill went through for something he didn't do. What made Hill hold on to his life is still astonishing. Despite this evidence, the prosecutors disputed the findings, suggesting that the hairs were unrelated to the crime and that the cellular material could have come from sweat or drool left over by the recovery team. It's shocking that the prosecutors were so stubborn, even in the face of such clear evidence. Harold and Young were eventually released from prison, but tragedy struck when Young was killed in a hit and run incident. Hill, however, filed a complaint against the city of Chicago, the police, and the two detectives involved in the case, accusing them of forcing a confession and violating his civil rights. The case was settled for $1.25 million, with Hill receiving $500,000, and the rest going to attorney's fees. It's surprising that the detectives were only asked to pay a measly $7,500 each for their part in this whole debacle. Do you think that is bad? Wait till you hear this. It's also worth noting that Hill was later convicted again for an unrelated armed robbery charge and is currently serving 27 years in prison. But despite this, it's clear that the justice system failed Harold Hill in the past. This case highlights the importance of reforming our justice system to ensure that wrongful convictions don't occur, and that those who abuse their power are held accountable. The case of Harold Hill is a tragedy of errors, starting from the investigation to the trial and subsequent conviction. Being wrongfully imprisoned for 13 years, Hill was not awarded a chance to conform to life outside because he was turned into a criminal by the system. The system absolutely messed the hell out of him, and the cops only paid $7,500 each. When cops do what they did, they need to be locked away for at least as long as the victims they put in jail. What do you think of these cases? Which do you think is most unfair? Sound off in the comments below and make sure to let us know if we missed out on anything. While you are at it, make sure to hit that subscribe and leave a like to never miss an update from us